Web developers, don't get sued for copying images from the web. Are you using images on your sites that you found on Google? My client did exactly that, and they were threatened with a predatory lawsuit and demands for tens of thousands of dollars from PicRights and their ambulance-chasing attorneys, Higbee and Associates. I'm Dennis Walsh, an intellectual property attorney and software developer helping other developers navigate the law. And in this video, we're going to get into the legal hot drama my clients experienced over simply copying a picture for internal use. What do you do if you get a letter from one of these jokers at PicRights or Higbee? And then finally, I'll go over how to keep you clear of these lawsuit threats. So quick aside and shout out to Carissa who asked for this video in the comments. If you have a legal software question, please let me know in the comments and I will cover it in a future video. So here's how the picture racket works. PicRights is a company in London that signs up major content creators like Associated Press and Reuters to protect their intellectual property. PicRights then reverse image searches their clients' images, and if your site returns one from the image search, guess what? You get a letter. This is how my client got entangled with this mess. My client is a local small business that I personally frequent. They have an internal question of the day designed to get their members talking by answering a silly question like, would you rather be a crypto bro or an attorney? Crypto bro. So to go along with these silly questions, they attach an equally silly picture to the website. And again, these images were for internal chuckles for their members only. They weren't using these images to drive business and provided little to no utility. So one day, out of the clear blue, they receive a demand letter from PicRights to pay up for their copyright violation or they're going to be sued. My client thought the whole thing was silly and ignored the PicRights letter. Enter Higbee and Associates, a sketchy law firm that's the hammer for this scheme, who followed up with a letter demanding thousands of dollars to settle the case. At first, I thought this letter was a joke too because it was so unprofessional. I've worked with some of the top national law firms in the country. None of those law firms have letterheads stating they're a national law firm or their corporate headquarters. Much like someone telling you they're rich or driving a lifted truck, things might not be what they appear. Also, I've represented plenty of clients that have had IP stolen, and it's always a cease and desist letter, not some heavy-handed, scary blurb that the infringer may owe $150,000 in damage and send the money to this website. I pulled up Higbee's website where I discovered a bunch of ambulance chasers and divorce attorneys moonlighting as intellectual property attorneys. It looked ridiculous. And their website posted a few proverbial case scalps explaining how they got copyright judgments from defendants that just failed to respond. Okay, so let's set the drama aside for a second and let's cover the law. Do these knuckle draggers have any case? To understand that, we need to understand copyright law. Copyright infringement falls under tort law. Tort is French for wrong. You can think of copyright infringement as similar to tort of negligence, like a car accident or a piece of glass mistakenly found in your restaurant's food. What makes tort law unique compared to other areas of law is that tort law is very concerned with damages. For instance, take a piece of glass in your food. The restaurant has an obvious duty of care to not have your food contaminated by glass. But is it lawsuit worthy depends on the damages. If you see the glass and remove it, what are the damages? If you eat it and it passes naturally without any issue, what are the damages? But if it causes intestinal damage that requires surgery, then what are the damages? The exact same negligence act occurred in all three scenarios, but damages makes all the difference. You could only sue in the last one. And that's where most copyright infringement cases fall apart, in the damages. The damages for innocent copyright infringement are disgorgement of profits or compensation for the creator's lost profit. Take the case with my client. Say they found a funny picture of President Obama and used it for the question, would you rather read your crazy Uncle Ted's political social media feed or dunk your head in battery acid? What are the damages? Well, it's impossible to say that they profited off that picture. So the damages will be the loss in licensing revenue. It's a few $1,000s at best. Now you're probably asking, okay, so if all you get is profits or licensing fees, where in the world does this $150,000 number come from? The $150,000 is from statutory damages. A plaintiff can collect statutory damages if the work was registered with the U.S. Copyright Office before the infringing use. As an aside, that's how the music industry took down file sharing. They registered all of the music and then went after everyone individually for $150,000 per song under statutory damages. In other words, all of the scariness that their letter rides on is if the images were previously registered. And Higbee will have you believe that they are. I wrote back asking for proof of registration. They claimed it was part of a group registration, which that happens. I said, that's fine. Show me the registration. And lo and behold, they couldn't. And they danced around it like one day they will magically find it and it would appear, but they couldn't be bothered with it right now. Hurry up and settle. That's their game. Scare people with crazy numbers, and then when they're asked for the goods, act like it's too much effort to dig them up. It was clear they were lying, so I took a picture of the federal courthouse from the business's parking lot and told them if there's any more communication, they can do it through that building. Never heard from them again. Okay, so what should you do if you get one of these crazy letters? First, of course, I'd recommend contacting an intellectual property attorney. That's a good idea. Then I'd recommend removing all of the cited images. Copyright damages can be willful and enhanced if you're sent a notice and you don't remove them. Third, really drill down on if they have a valid copyright registration with the US Copyright Office before blowing anything off. Eventually, these ambulance chasers will have a client with a registered copyright, and that's a little more serious matter. But really, try to head these things off before they begin. I'd recommend going through all of your various websites and make sure you have permission to use all of the pictures. I, for my websites, tend to use Midjourney to generate my blog images, so I don't need to think about stuff. Yes, it can look like AI slop, but the images typically get my point across, and I don't have to worry about any of this mess. So, hopefully you found this helpful. If you did, please do the like and subscribe dance, because up next, I'll go over the legality of same.dev copying websites and talk about LLMs changing the legal world. A lot of developers seem interested in Twitter, so I'll go over it in depth. And of course, we'll keep covering the WordPress versus WP Engine case. And please let me know any videos you'd like to see to help with your web development.